Many parents do not think of a text message to their co-parent as a future exhibit in a court file. I do. You might think of it as a quick checkup on pickup time, a frustrated reply to a missed exchange, or an honest comment about something the child said. By the time the question matters, by the time it comes up, the choices about where and how to communicate have already been made because you've sent the text message and it is now a potential exhibit in a court hearing. Many parents do not think of a text message to their co-parent as a future exhibit in a court file. You might think of it as a quick checkup on pickup time, or a frustrated reply on a missed exchange, or an honest comment about something the child said, or an honest comment about how you feel. Well, I see it as an exhibit in a trial hearing. I see it as evidence that can go to a child and family investigator that can talk about how you are unable to communicate with the other parent, or how you can make things complicated for your own purposes. There are so many different ways you can use exhibits, such as text messages and phone calls, voice messages, and Facebook, social media posts, all that sort of thing. If you're in a custody case, what you really want to do is you want to treat anything you put in writing as if it is already before the court. If the judge reads this text message, how will that make me show up? If the judge reads this Facebook post, how will I look? How will I explain it? It's best to, even if you can, just avoid social media during the time period that you're involved in a court case, because then you don't have to worry about second guessing what you would normally post that in this particular situation could show up and make you appear in a bad light. Understanding that from the moment your case starts until it ends, it's very important. Don't make the mistake of being the witness against your own self in court. Text messages and personal emails between parents are generally admissible in Colorado family law cases. Whether they are easy to admit is a different question. Authentication requires testimony. The parents offering the message may need to confirm it was sent, identify the phone number, and explain how the screenshot was produced. There are a lot of things that go into the ability to enter evidence into the record. Now, on the flip side, a message that you want to use can be lost. Phones change, accidental deletions happen, automatic cloud backup policies affect the fact that they're no longer in existence. A reply that mattered 6 months ago, when you go to trial, it may not be retrievable today. There are apps that can help you co-parent, and oftentimes the court orders the parties to utilize these apps. Our Family Wizard is among one of the most widely court-ordered platforms. It includes messaging, a shared calendar, expense tracking, and a tone analysis. Records export in a format designed for court use. So all those messages can be downloaded and exported and used in court. They can be given to the child and family investigator. They can be given to a PRE. So you need to pay attention to what you say in those apps, but you also need to comply with what the court is asking you to do. You can't refuse to use the app. I have seen many parents refuse to use the app. And while I can understand how you might not want to be forced to communicate that way, to have to write down your requests, to have to account for your expenses or your wishes in writing, if it's a court order, it's a court order. Talking Parents offers many features that you can utilize to try to make your life easier if you want to try to look at it that way. There's no single best app. The right choice depends on the court order, the budget, and the features that matter for your case, and the practicality of how you can afford it and how you can actually input it. I would investigate the different types of software and apps available and even make a recommendation for the one that you prefer, rather than having the court choose or having your opposing party choose. The same audit trail that captures your co-parent's communication captures yours. A parent who treats the app as a venue for litigation, who writes messages designed to provoke a response, who documents every minor frustration in inflammatory language, you're building a record that reads against you as much as against the other parent. And a few good habits can help. Assume a judge will read every message you send. If a message would not look good projected onto a large screen in a hearing, it should not be sent in that form. Keep your messages child-focused, factual, and brief. State the question, the relevant information, your specific request, and your time frame. And that's it. The app is a communication tool. It's not a venue for a deposition. It's not a journal. It is an opportunity to have simple, succinct communication with your co-parent so that you can co-parent. Non-compliance with a court-ordered communication app is a real and common problem. Ways to protect yourself against it is begin by documenting the non-compliance through the app itself. Send the invitations, send the requests, send the messages that the orders require. The fact that the other parent does not respond or has not signed up will appear in the app record. That is the foundation of any enforcement motion. Do not stop trying to communicate about the children. You will want to because you'll say there's no point. They never respond. They never signed up. But then you are not in compliance. And when you go to say that they're not complying, you know what they're going to say? You're not complying. Communication between co-parents is part of your case. It is not separate from the case. The channel that your messages travel through, they shape what can be preserved as evidence, what can be preserved as documentation, and what can eventually be authenticated if it has to be shown to a judge in a dispute later on. The tools matter less than the discipline of the parent using it. A thoughtful, child-focused, factual record built over time tells the court more than an individual message. So if you're starting a Colorado family law case, you're considering modifying an existing order, or you're trying to understand how your communication record may affect your case, schedule a free consultation with Jones Law Firm to talk about where you stand.